It's Mr. Turney, in fact, my lady.
Oh, I'm terribly sorry.
I don't know if I'll
Mr. Turney.
I appear with Mr. Fulbrook.
Thank you very much.
And my learned friends, Mr. Musser, Queen's Counsel, and Mr. Coates for the Secretary of State. Thank
you very much. So, may I start by thanking everyone for their skeleton arguments, which address the directions given both by my lady, Lady Justice Simler, and my lord, Lord Justice Dingemans. As you'd expect, Mr. Turney, what we're going to do is we're going to start off with the argument relating to whether or not this is an academic appeal. And then, subject to our decision upon that issue, we will take, as it were, a housekeeping session where we address where we are going and how long people will have to address the particular substance of the appeal. But shall we start straight away with the preliminary issue of whether or not this is an academic appeal?
My lady, yes. I just say at the outset that we, I think, have expressly recognised that the relief which we originally sought in these proceedings is no longer properly available to us, in the sense that we say that the relief to which we are now entitled and that the relief this court should give would be limited to a declaration as to the application of Section 40 to the Secretary of State's decision-making in next steps, and as to the breach of Section 40 in the decision to adopt next steps. So that's as far as I put the case.
Thank
you. The reason, in short, why I say the court should consider that issue and why it should entertain this appeal on that point is that this is not an issue which is confined to the particular facts of decision-making in March 2020 in respect of next steps. There is an ongoing, controversial policy in respect of badger culling. It is a policy of this Secretary of State, and it is one which evolves regularly and which is scrutinised and indeed repeatedly challenged both by my client and by others. The question of whether and in what terms the Section 40 duty applies, therefore, is an enduring question. It is not one which will go away because of what has occurred in this case. So that's the headline point. The court will be well aware of the principles that have been set out in Ex parte Salem, which is referred to in the skeleton argument. The only other authority that I wish to refer to, and it wasn't in the bundle for which I apologise, I picked it up later, is a case that my Lord Justice Haddon-Cave was in, which is the case of L and Devon from last year. And I'm just going to show that to the court, if I may.
Yes,
simply
please.
Because it's very recent consideration by this court of the principles. Can I hand that copies?
Paragraphs 38 and 64?
Yes, I'm very grateful.
Thank you very much.
So, I understand from the intervention from my lord that the court will know this case, but very briefly, a claim for judicial review in respect to the local authority's failure to produce amended education and healthcare plans within a statutory time limit. The issue between the parties was whether the proposed amendments to those plans had to be issued at the same time that the authority issued its statutory notice, or whether the obligation was to issue a final plan within 8 weeks of that statutory notice. After the claims had been issued, but before permission had been granted in the case, the local authority issued the relevant plans. So the relief which was sought, which was mandatory relief to compel the service of the plans, had already been practically achieved. In the High Court, the judge, His Honour Judge Alan Gore, Queen's Counsel, sitting as a deputy judge, found that the claims had become academic and dismissed them accordingly. And on appeal, this court considered whether the judge was correct to have done so. The court, in its majority, left open the question of whether, strictly speaking, the claim in those circumstances had become academic, although it's right to note that Lady Justice Lang, who gave the leading judgment, inclined to the view that the claim had become academic, and that's paragraphs 48 through to 50, because all of the practical relief which was sought by the claimants in that case had in fact been obtained before the High Court hearing. But nonetheless, the court found that the judge should have determined the underlying claim. Paragraph 52 in particular the factors identified by Lady Justice Lang as to why the judge should have decided the claims. The parties were before the court, permission had been granted to apply for judicial review, and there'd been a determination at permission stage that the claims were not academic, and everyone was there and had incurred the cost of preparing for the hearing. It, in fact, in that case, was not taken as a point by the respondent. It was taken as a point by the judge that the claims were academic. The parties were ready to argue a point of statutory construction, and they did, in fact, argue it in full at the hearing. And it was a short point, and it was one that raised general issues of public interest. There was also an indication by the judge that he would give his view on the construction issue. And the parties had expended the time and money in preparing for and attending the hearing. Court time had been devoted to it, and the overriding objective would be furthered by deciding the claims rather than not doing so. Then at paragraph 53, the question of whether there was anything in this case which compelled the judge not to decide the issue, noting that there was a discretion even if the claims were academic, the court accepted that the reasons which the judge gave for refusing to exercise that discretion are circular, in the sense that either an argument that he had no discretion or reasons which would apply to every academic claim clearly would not be good reasons for not hearing the claim. That's the thrust of the decision on the substance. The judgment of Lord Justice Peter Jackson, which follows at paragraph 60 and following, gave some more consideration as to what is an academic claim. Noting first of all at 61 that the court had decided that the judge should have heard the claim anyway, and it was unnecessary to find whether or not the claims were academic, but the judge considered what was meant by a claim being academic. The claim will be academic if the outcome does not directly affect the rights and obligations of the parties. And the matter will be put in a number of similar ways in various authorities, and those are set out. But then explaining further, in particular at paragraph 65, whether a claim is academic will, as is said above, depend on the particular circumstances. But one reason why the present case is difficult to categorise is because the relationship between the parties is ongoing. The process of review and reassessment is an iterative one, and the children likely need annual plans throughout their education. There is at least a real likelihood that the issue that arose this year will arise for one or more of the claimants in future years. It is in that sense that Mr. Justice Eady considered that the issues remain live between the parties. At all events, the outcome is of potential future significance for the claimants, as opposed to being a dispute that is now, so far as they're concerned, in the past. It's also significant for the respondents and for others. So, and then noting at paragraph 66, if there's doubt as to whether the claim is academic, that will no doubt be one of the factors that the court will take into account when deciding whether to hear it. Those were the core parts of that case. Obviously, the facts are different, but I do say that in this case, there are some parallels. The only way in which it is said that this claim has become academic is because after the High Court judgment, the Secretary of State carried out a further consideration in respect of the ecological impacts of his badger culling policies. That's set out at some length in a ministerial submission accompanied by a document from Natural England which postdates the High Court hearing at least, and possibly also the judgment, and contains various references to those ecological impacts. And the Secretary of State confirmed, having considered that he maintained his position as set out in the impugned Next Steps document. That material only came to light after this court had granted permission. It was not produced by the Secretary of State when the decision was made in December. It was produced in the respondent's notice after this court had granted permission in April of this year.
Would you accept the effect of that reconsideration by the Secretary of State was to pull the rug from underneath your main claim?
In the sense of the relief that I seek.
Yes, so that you no longer needed the relief, or entitled to the relief. But surely, it's paragraph 65 of L&M, which is critical, that the facts there were very different. There was an ongoing relationship between the parties, and as the Lord Justice Peter Jackson says, the outcome of the case was of potential future significance for the claimants.
Yes.
And so, struggling to see how this decision helps you at all, because it's again a decision on the facts as to why it was not academic.
My Lord, I perfectly accept that any decision will be highly fact dependent, and therefore L is just a recent example of this court's reasoning as to the application of the principles. So I don't seek to draw too heavily on a parallel. But the reason
here there was an ongoing relationship
yes.
between the parties, which the decision would affect.
Well, my Lord, here the ongoing relationship is obviously different in the sense that there isn't a person subject to the same sort of plan or ongoing process of dealing with special educational needs. However, there is an ongoing relationship, and if I just give a very brief potted history, it's this. In 2017, the claimant challenged the Secretary of State's policy in respect of supplementary culling, and also challenged Natural England's decision-making in respect of cull licences in relation to the way in which Natural England assessed the impacts on European protected sites. As a result of that litigation, Natural England issued substantial updated guidance in respect of the assessment of ecological impacts on European protected sites, and that was in 2018. The document's in this bundle and was referred to by the judge. In 2018, a further claim was determined by Sir Ross Cranston in respect of the assessment of impacts of badger culling on SSSIs, sites of special scientific importance. And those sites had been subject to some assessment by Natural England. Again, in the face of the claim, Natural England changed its approach to assessment, including in introducing new and different conditions in respect of badger licences in the face of the ecological evidence that was relied on by the claimant in that case. After that litigation, the claimant and Mr. Woodfield, who's the ecologist who has given evidence in respect of each of the claims, including this one, engaged directly with Natural England, including with their chief scientists and various technical officers, in respect of the assessments that are carried out on the ecological impacts of badger culling. So there has been ongoing engagement between the parties on this point as to the extent of the assessment. Now, European sites and SSSIs are those protected sites which account for about 10% of the land in the cull areas. The other 90% has biodiversity interest but is not subject to those specific site protections. And the Section 40 duty is then the residual duty in respect of biodiversity that applies to that wider area. So we say the question of whether and what needs to be done by A, the Secretary of State, and B, not in this case, but in others, Natural England, in respect of Section 40 and assessing the biodiversity impacts of badger culling outside of protected sites. That remains effectively a live issue.
But isn't the precursor question whether or not Section 40 was engaged in the first place, which is what Justice Griffiths' judgment rightly focuses on? And his decision there is again very fact-specific on the basis of the slightly unusual timetable in this case. So again, I'm struggling to see how an appeal, full-blown appeal on that question of whether or not Section 40 was engaged could be of wider significance, given that decision of engagement has to be determined on the basis of the specific chronology here.
My Lord, yes, it is concerned with the particular chronology, but the position that's adopted by the judge, I don't want to descend too far into the merits, but effectively, the judge made the following points. The first one is that Natural England, I won't take them in the right order now, but Natural England consider this matter anyway. Now, that is a question which would go to any determination by the Secretary of State in respect of badger culling policy. If it is right to say that the Secretary of State does not need to comply with Section 40 because of something that Natural England may or may not do, then that would be a point which would be relevant to any decision of the Secretary of State in respect of badger culling, and it's not dependent on the particular chronology. The second point is that the Secretary of State had previously considered the ecological impacts through a report prepared in 2011. If that is a good enough reason for Section 40 duty not to be engaged, that reasoning would apply to any subsequent decision of the Secretary of State in respect of badger culling policy. Then the Secretary of State, having omitted to consider the matter, that the Secretary of State was only maintaining a policy as opposed to changing a policy, another part of the judge's reasoning. Again, that would apply in any event for any future decision. In other words, unless the Secretary of State at some point decides to stop culling or to somehow materially change it, he would never be required to consider the biodiversity impacts by dint of Section 40. And then there's the ground 2 issue, which is, should the Secretary of State in any event have asked himself the question about what evidence was available about the ecological impacts?
Are you veering off course at the moment? I know, as you said to my lord, that you don't want to get into the merits, but if you're getting to ground 2, I think you are. I mean, can we stick with the question of whether or not this is an ongoing relationship?
Yes.
I think the points that you've raised are that there is a precedential history here that suggests that this is an ongoing topic and not one that's disposed of by any discrete judgment. But are there any other points on that issue going to L&M that you say, to my lord, distinguishes or puts us on the same footing as L&M?
Well, it's the context is clearly different because we're looking at a matter of national policy as opposed to a question of individual decision making for particular children. But there is an further ongoing relationship because there are further commitments to review within the policy. In other words,
as you indicated.
Yes. So the Secretary of State says that he will continue to look at badger culling and consider other options. So query whether when he does so, he must consider Section 40 or must he not consider Section 40. And in respect of licensing, licenses are issued on an annual basis. In other words, there are new and different licenses issued for badger culling every summer. So I do say that it's a different context, but there is an ongoing relevance of the point. And whilst I don't want to veer into the merits. I do say that the duty of inquiry point is of ongoing relevance, because if the Secretary of State has to acquaint himself with facts, then that is something which he will need to do before he takes further decisions in respect of badger culling.
Just on that specific duty, I understand that point, and without getting into the merits too much, that wasn't a point which appears to have been taken directly before the judge. Is that fair?
It wasn't taken in the pleadings, and that's the point that's taken by my learned friends. It was taken directly before the judge, specifically and in terms on a tame-side basis.
Right.
But it wasn't. The pleading is. This is a case where where the original. We're looking at a small part of the original pleaded case, and the original pleaded case was in very short form on this section 40 point.
Can I also just ask, whilst on the pleadings, on the claim form, it was the defendant's decision to publish the next step strategy, not to adopt it. It's very odd to challenge someone's decision to publish a strategy unless you're actually saying you shouldn't be adopting it. Why was it publishing rather than adopting the policy?
If the language was wrong, that's my fault. But
Nothing turns on that. It was okay. That's fine.
Turns on it.
I just wanted to check that was the position, because normally you would say you shouldn't adopt this policy. Fine, but you shouldn't publish this policy. Is a very narrow point.
In the planning field, where I do most of my work, policies can be formally made part of government policy, depending on the statutory context, by either adoption or publication. The words are used seemingly interchangeably in the legislation.
I understand that in certain planning structures, but this was just a government policy, as it were.
I think maybe the better word would have been adoption.
Anyway, but fine, as long as nothing turns on it. Sorry to interrupt you.
Turns on it. I think in respect of to go back to my lady's point, I think there is an ongoing relevance for what the Secretary of State will have to do when he next comes to review his policy.
Yeah, I've got the point. It was just that we were veering into the merits a little. But
yes.
The point is there that you make. This is the general header going to the continuing relationship.
Yes.
Yeah.
The other point that I'd make is simply this, and I know this does veer to some extent into the merits, but I think most of the cases recognise you have to make a fact-specific determination. But if I can put it in this way, this is a decision about perhaps the single largest intervention into the ecology of England. And it's a decision by the Secretary of State, who is responsible for implementation of the measures under Section 40. And I say in those circumstances that the judgment of Mr. Justice Griffiths is stark. If the duty doesn't apply in this case, then when does it apply? And I say that's a good reason for this court to hear the appeal. I realise that descends a bit into the merits, but that's a good reason for this court to hear the appeal, because it is a stark decision that the duty does not apply in respect of the Secretary of State for Environment's decision-making in respect of national badger culling policy.
May I ask two further questions? The Section 40 has been amended by the 2021 Act, but it isn't yet in force. Does that have anything to do with whether we should be engaging with looking at a statute that might change?
My Lord, I say no for two reasons. One, we don't yet know when it's going to be commenced.
That's certainly my understanding.
Yes. So it's on the statute books, but it may not be commenced. The second point is that all the material around it indicates that the Secretary of State's own view is that the duty is strengthened by those provisions, and I won't get at all into any submissions about the detail of those amending provisions. But the Secretary of State's view is that the matter is strengthened, and indeed, in the ministerial submission at the end of last year, which has led to this argument about whether this claim has been rendered academic and shouldn't be heard, the civil servants briefed the Minister that Section 40 will be strengthened if the provisions in the Environment Act are commenced. So, in that sense, the argument about whether the duty applies as it currently stands would resolve whether it applies as redrafted. this is a strengthening of the duty. It's not the sense that, for example, that the duty was about to be abolished. It is going to be strengthened.
Thank you. The second question I wanted to raise was, because I get to see the forthcoming appeals, etc., I've not been able to determine, in relation to public law, which I'm the supervising law justice for, I've not been able to determine whether there are any other cases raising the Section 40 point, because obviously determining an academic appeal, if it is academic, might be more important if there's a stream of cases out there. At the moment, I can't see any others, but you're likely to have better information than I have.
I'm not aware, my lord.
No,
I don't specifically rely on any other cases that are currently in the pipeline. It's a duty which has been considered briefly by the courts, although it hasn't had substantial judicial consideration, I think it would be fair to say, despite it being on the statute book for some time.
Just on your answer to my lord's point about the fact that we can see that there are significant amendments on the stocks, as it were, but we don't know when they'll come to that. And your point, well, that this is strengthening the power, and ergo, it's all the more reason why the court should now look at it. But you're right in a sense, because it's not just conserving, but it's the positive duty now of enhancing, which, in terms of character, in a sense, it's a different duty. And speaking for myself, I have some difficulty in submission that the court should look at and opine about this power, even though it's going to change. It's not just more conserving, it is actually a different animal. It's conserving and enhancing, so there's a positive duty. And isn't the court in a bit of difficulty in opining on the current wording when the wording is going to change in character, the duty in character in due course?
Well, my lord, the way it's framed to apply would remain the same, and the duty to conserve or to consider the purpose of conserving, not to conserve, but to consider the purpose of conserving, would in substance remain the same. Now that's the heart of the point that's taken in this case. So whilst there may then be arguments about how much further must a Secretary of State go in considering enhancement of biodiversity in any given case, in my submission, the finding that the duty to conserve is engaged would answer the question also for a future determination under an amended Section 40.
Yes, is it a disjunctive or conserving or enhancing? Can you?
Well, so I think it may be. I won't make full submission. It may be that it would be taken to be disjunctive in the sense of.
And so I've been creating a disturbance on the pitch.
There may be enhancement whilst causing harm, for instance, which is offsetting biodiversity. The centrality of the duty, though, is not changed. And it just momentarily, again, I don't want to send too far into the merits, but the duty comes from the 1992 Convention on Biodiversity. It's the implementation of an international obligation. That international obligation, in fact, is now reflected in, for example, the Trading Cooperation Agreement with the EU. It is a firmly embedded duty in respect to biodiversity, which certainly isn't going to go away quickly. So I don't accept the principle, the argument that's put by my learned friends, that the fact that the wording is going to change, which on the Secretary of State's own view is a strengthening, means that an argument about the provision as it's drafted and whether it applies at all to this decision making has been rendered academic such that it shouldn't be heard by the court. I'm reminded, of course, that the other point in L was that they were there, the parties were there, and I do say that that's actually a good reason here in light of the circumstances. And we had a complaint about the way in which this matter came before the court. Lady Justice Simler has dealt with that, but we were concerned that the Secretary of State did this further consideration, having received Mr. Justice Griffiths' judgment, resisted the application for permission to appeal, and only told us about it after Lady Justice Simler had granted permission to appeal and ordered expedition of the case. So, in other words, it's all the circumstances in which this has come about is, in fact, a peculiar feature of the case, and indeed the admission of the evidence that is said to render the appeal academic. That decision was made only 3 weeks ago.
The hearing before His Honour Judge Alan Gore, you see, was de novo. It was not an appeal. And the parties were all before him. So it's a slightly different scenario from this, isn't it? This is putative appeal.
But my lord, I accept that, and I myself can't see a clear distinction in the reasoning of the courts on this issue between academic appeals and academic claims for judicial review, save for the distinction that is made between public law cases and private law cases. But an appeal in a judicial review, I cannot see a different set of principles being applied by the courts, and it may be that my learned friend says there is a different set of principles. But in any event, the parties are here. The factual circumstances only arise because of the exceptional course, as the courts have recognised, the exceptional course of admitting new evidence on the appeal. It's not a situation where something has happened entirely outside of the process. And the final point, I think, is this, that the appellant, the court would have seen the correspondence, invited the Secretary of State to simply concede that the duty applied and for the appeal to be disposed of on that basis with a declaration that the duty did apply and no further relief. That was the suggestion that was made to settle the appeal a few weeks ago, and that suggestion was rejected by the Secretary of State, who said the appeal should simply be dismissed, which of course is the course that is advanced now. We say this could have been dealt with simply by that concession.
Well, that would have been a concession against the judgment of Mr. Justice Griffiths.
It would have been, and the court would have to have reflected that in an order under the practice direction, and we would have needed that to be endorsed by the court because the appeal would have been allowed on that basis, on that limited basis, but with no further relief.
Right. Well, whilst I can see that there is something to be said for the manner in which the Brown 3 document came before you and then the court, I do find it rather odd to suggest that the Secretary of State would go against the determination of a judge of the High Court that hadn't been subject to review by the Court of Appeal.
Well, my lady, in some cases that might be right, but of course, as I say, the Secretary of State is responsible for the implementation of this duty and is the person who promotes that duty and seeks to strengthen that duty. And
yes, but there's got to be a reason, hasn't there, Mr. Turney? A reason to say, well, this is the judgment of the court, but accepting the judgment of the court as we must, nevertheless we see X, Y, and Z applies. But you were asking that there be a concession that the judge was wrong.
Yes, because the view that the appellant takes is that in this case, the Secretary of State has protested too much. In other words, the Secretary of State has led to a position where the statutory duty for which he is responsible is now substantially watered down by a judgment of the High Court that says it does not apply in respect of potentially the biggest intervention in the ecology of
which is the argument that you're putting forward as an exceptional reason for the case.
Precisely, it's the start of this point.
Okay. All right.
Unless I can insist further on the academic issue.
No, thank you. Mr. Fallbrook, you don't follow? Do you follow?
No, thank you, my lady.
Thank you. Mr. Musa.
My lady, I'm grateful. I'm going to divide my submissions on the academic issue into two sections. I'm going to deal firstly with the implications of it being common ground that ground 4 of the appeal is academic and does not need to be considered by the court, because there is in fact common ground that at least part of the appeal is academic and forced to be dismissed on that basis. And then secondly, I'm going to deal with my submissions on grounds 1 and 2, which are the remaining substantive complaints in respect of which the claimant seeks a declaration. Now, in relation to ground 4, I need to show the court the genesis of it, and the genesis is in the judgment of the judge, which you'll find in the core bundle behind tab 3. And if I can invite the court to take up page 104. In paragraphs 99 and 100 of his judgment, Mr. Justice Griffiths gave an independent and sufficient reason for dismissing the claim for judicial review before him. And that was because of the application of the duty in section 31, subsection 2A of the Senior Courts Act 1981. So he concluded that even if the Secretary of State had done what the claimant said he was required to do, it would have made no difference to the outcome. And on that basis, the administrative court was not only entitled to, but was obliged to refuse all relief, including any form of declaration. The statutory provision bars all relief. And that was one of his reasons for his order, which you can see in the next page, that the application for judicial review be dismissed. And it was a sufficient reason for that order. As to the grounds of appeal, you'll find them in the first tab of the core bundle, and I can take you to page 15 if I may. The court will see that ground 4 focuses on this independent and sufficient reason for dismissing the claim for judicial review. It sets out an argument that the judge erred in finding that the outcome would have been the same. And it's the only ground to impugn that separate basis for the order. This ground is no longer pursued. It's agreed that it's academic and there's no exceptional public interest in the court determining it. That has significant consequences for this appeal. My submission is that there are two consequences. The first is that the appeal against the judge's order must necessarily be dismissed. This is because the judge's second and independent reason for dismissing the claim stands. The order was justified on the basis of that reason in any event.
On any view?
On any view. On any view. And secondly, it goes further, my lord. No further relief is available to the appellant in this appeal in respect of the Secretary of State's original decision that was challenged by way of judicial review. The Court of Appeal would not be able to substitute for the judge's order an alternative order providing for such relief, including a declaration. I can explain that in two ways. The first is that the judge's decision to refuse the appellant all relief, because he was bound to do so under section 31, subsection 2A, is no longer being challenged as wrong and cannot be held to be wrong. This court proceeds on the basis that the administrative court was obliged to refuse relief. The second way of explaining the same point is that on an appeal, and when determining an appeal, this court exercises the powers that were available to the lower court. Now, in this case, the judge, the lower court, did not have the power to grant any relief in respect of the original decision, because section 31, subsection 2A, operated to bar the grant of relief. It follows, given that that conclusion is not being reopened on this appeal, that you do not have the power to grant such relief either. So insofar as we are here before you today because Mr. Turney seeks a declaration as to a breach of Section 14. That really gets him nowhere. This court is not in a position even to grant that declaration, given the way in which the appeal has developed and given the fact that there's no longer an issue concerning ground 4. And I make that point at the outset because all of the cases you have in the bundle concerning academic claims and academic appeals were all cases in which the court had the power to grant a declaration. And it was a question of its discretion. Should we entertain this claim and grant a declaration even though it doesn't have practical significance? The court's role here is even more restricted. There's no declaration available. It would only amount to writing a judgment commenting on grounds 1 and 2.
So you head him off at the pass on this and say that's the end of the matter?
That is the end. The appeal has to be dismissed, given that ground 4 is no longer being pursued, and that there was an independent reason that the judge gave for dismissing the claim for judicial review, which is no longer contested before this court. But even if the court is not with me on that threshold point, I say that the remainder of the appeal is academic in any event, in accordance with the ordinary authorities. I don't think there's any substantial dispute on the law, but I ought to just take the court back to the Ellen Devon case. But I'm not sure that Mr. Turney showed you a couple of passages which are particularly germane to the present case. I don't think it's in the authorities bundle, it was handed up separately.
Yes, we have it.
I'm grateful. So paragraph 50 in the judgment of Lady Justice Elizabeth Lang. And she's here explaining her reasoning for inclining to the view that even these claims were academic.
But did you say 15?
50, sorry.
My fault.
And it's important to note that the other members of the court concurred with her judgment and concur with her inclining to the view that even these appeals were academic. And one sees the focus on the question of the practical necessity for relief. The jurisdiction to dismiss cases as academic is part of the armoury of the court. It enables the court to avoid hearings in cases in which, although the issue may be arguable, there's still a disputed issue if you can have an argument. The court is not required because the court's intervention is not required because the claimant has obtained, by one means or another, all the practical relief which the court could give him. I incline to the view that the claims in these cases were academic because the A's had obtained all the practical relief for which they had asked. That is the issue of the final amended statements. There's still a potential issue, but it's no longer live, and it's no longer live in these proceedings. So it's practical significance in the particular proceeding. Question of relevance to future cases is dealt with in considering whether there is an exceptional circumstance justifying consideration of an academic appeal in the public interest. And in terms of the reasons why Lady Justice Elizabeth Lang thought that this was a case the court should consider, the main reasons aren't actually set out in paragraph 52, to which Mr. Turney took the court. 56 is the paragraph that deals with the Court of Appeal exercising its discretion. And you'll see the matters that are set out there are firstly that the dispute in that case was a pure issue of statutory construction. It simply concerned the construction of provisions concerning time limits in certain secondary legislation. Issue affected many young children who have EHC plans, so it was a common issue. The very issue was common to many others. Even the respondent conceded that it would arise again. Moreover, unless the issue was resolved in that particular case, it was unlikely ever to arise again for determination because it was never going to be live in an application that was brought in the future. And fourthly, this was a case in which the facts were simple. The facts of the case were not in dispute, and as I've noted, it was a pure issue of statutory construction that the court was dealing with. We are a million miles away from the Devon case. I'll come on to make my submissions on why the issues under grounds 1 and 2 are academic and should not be considered. There's no exceptional circumstance requiring that to be considered in the public interest. Well, Mr. Turney submits that this is an important case about the Section 40 duty, and he says that is what justifies the court looking at this case. If I can take the court to what the pleaded claim actually was that the judge had to determine, you will find the pleading, I might just find my own note, Core Bundle tab 4 at page 135. And the court will see there's a ground 3, and 3A is a failure to consider ecological impacts altogether. Paragraph 67 starts, there's no dispute culling can have wider ecological effects. In adopting next steps, no consideration whatsoever was given to the ecological consequences of continuing culling. This was a material consideration because, and then we have a reference to the Section 40 duty. So the Section 40 duty is relied upon indirectly in the pleaded claim as a justification for particular matters being a material consideration that the Secretary of State was required to consider. And the second justification for that, we will see over the page, was that the adverse ecological consequences of culling have been expressly raised by the Godfrey Review. So those were, the Section 40 duty is just relied upon as one of the reasons why the Secretary of State is said to have been required to consider the ecological consequences of continuing culling, which aren't actually specified in the grounds. And that was it in terms of a pleaded case before the judge. And he makes a point of noting that no application was made to amend this pleaded case in his judgment at paragraph 6. Now, as I say, this case raises Section 40 indirectly on the pleadings before the judge. In any event, as the court has already been informed, the Section 40 duty is now changing. It has been amended by Parliament, and the only question is as to when the revised duty will come into force. My submission is that there are material and significant differences between the revised form of duty and the duty that applied or was before the judge in this case. I can take them relatively shortly. If I can show the revised provision, show the court the revised provision. It's in the authorities bundle at tab 4. Page 31 is where we find the new version, and just for the court's information, you can see the old version at page 29. And I make the following points. Firstly, the new Section 40 duty will impose an obligation of periodic consideration. So 41 provides a public authority which has functions exercisable in relation to England must from time to time consider.
And where are you reading, sorry?
Section 40 subsection 1 of the new version on page 31.
Thank you.
And what's involved with from that obligation, what's involved with considering from time to time is further specified in subsections 1C and 1D. So the first consideration has to take place within a period of a year, and the subsequent consideration must be completed no more than 5 years later. So the very issue of the application of Section 40 is dealt with in a different way under the new regime. The second point I make is that the matter which has to be considered is now different. Under Section 41, what we will fall to be considered is what action the authority can properly take, consistently with the proper exercise of its functions, to further the general biodiversity objective. So it's a focus on the authority's own action. And the general biodiversity objective is just defined in subsection A1 in different terms. It's the conservation and enhancement of biodiversity in England.
But what's common to both the section 40 and this revised section is consistently with the proper exercise of its functions, which was the subclause on which the judge held his hat for the judgment.
That's correct, my lord. It's
Well,
correct.
I think we've got the point. There's a different statute, but taking us
Yeah.
through this in minute detail
No,
is descending into the merits. And also, you're not addressing the main point which Mr. Turney would make on his behalf, which is that the critical wording is the same.
My lord, I can draw it to a close there on section 40. Secondly, it was submitted that the judge's reasoning in this case was of wider application to other cases. My submission is that the judge's reasoning was fact-specific. I don't wish to take the court through the detail of that, but if I can just summarise the points on which the judge relies in his judgment and provide some references. The judge relies on the fact that in the context of the particular function being exercised, next steps was a response to the Godfrey review, and the Godfrey review had presented no new relevant evidence on the ecological effects of continuing badger culling, paragraph 93 of the judgment. Secondly, the judge focused on what next steps sought to change. Next steps did not effect any change so far as badger culling or supplementary badger culling was concerned, except to suggest that it should be ended in the foreseeable future, paragraph 96. Thirdly, the judge focused on the nature of supplementary culling, noting that it aims only to keep the badger population stable at its current post-cull levels, rather than reducing it any further. Fourthly, the judge, that's paragraph 97. Fourthly, the judge focused on the fact that on the basis of the evidence before him, there was no new evidence concerning the ecological effects of continuing culling, no new effect that he could identify. Fifthly, commissioning
Give us
new
the paragraph number for that one too.
I do forgive me, it's paragraph 95.
Thank you.
Fifthly, commissioning new research was exceptionally difficult for practical and methodological reasons, for the reasons that Dr. Brown, on behalf of the Secretary of State, had given in her evidence. That's paragraph 92 of the judgment. And sixthly, in the circumstances, there was no prospect of obtaining new or meaningful evidence in the near future, so within a time frame to make a difference to the particular decision that was contemplated. That's paragraph 93. So my submission is that the judge's reasoning in this case is dependent on the facts. There may be some factors that he relies upon that may arise in future cases, but his decision in this case was based on closely reasoned factual arguments before him. And in my submission, this is not one of those cases. It's certainly not a case that raises a short point of statutory construction, which the court can readily resolve and which will be of assistance in future cases.
Or a pure point.
Or a pure point. It's about application, my lord, rather than pure meaning. There are not, in this case, a large number of further cases that will be directly affected by the present case. The judge was only deciding the pleaded case before him. His reasoning, as I said, depended on the particular facts. The relevant statutory duty is being amended in any event, and I'm not aware, in answer to my Lord Justice Dingemans' question, of other cases raising Section 40 pending before the court.
Thank you.
If you're right about that, and you presumably say that it's difficult and for this court to make a decision on the construction with a wider curtilage, because the court would have to, in a sense, theorise about the potential applications, which leads to all sorts of difficulties because it's a decision on construction in a vacuum.
Indeed, my lord, and it's particularly difficult in this case where as my Lord Justice Dingemans put to me, the duty itself is referable to the particular function that's being exercised, so far as consistent with the proper exercise of the function. Now, in this case, the court would only be considering one particular function, one particular decision that was taken, and in a quite special and specific context, statements being made about the phasing out of supplementary culling in the next steps document. Dealing with any issues of construction against that factual matrix doesn't provide a sure or secure guide to any general issues that might arise in future cases. And the only point which I understood Mr. Turney to make on why he says this case, beyond those I've dealt with, why he says this case should be dealt with and is not academic, is that he says there's an ongoing relationship between the claimant in these proceedings, Mr. Langton, and the Secretary of State. My Lord, my Lady, my Lords, it's certainly right that Mr. Langton has commenced proceedings against us previously, and so far as concerns the Secretary of State, all of those claims have been unsuccessful. But it's wrong to suggest that there's any form of ongoing relationship between Mr. Langton and the Secretary of State, so far as concerns the Secretary of State's decision-making. His points, as he made them, were directed to natural England, and it's suggested that there's been some liaison between the experts who have acted for Mr. Langton and natural England. I can't comment on that one way or another. Natural England are not my clients. I don't know whether there has been that liaison or what extent of liaison there has been. But in any event, it doesn't establish an ongoing relationship remotely close to the type that was considered in the Devon case, which would justify the court's intervention. So, my Lady, my Lords, those are my submissions on why ground one is academic and there is no exceptional public interest in considering it. I'll deal very briefly with ground two, which is the Thames side point, duty of inquiry point. And I make 2 points here. First, as I noted, the appellant appears to be relying on a form of Thames-side duty, which is part of the obligation to act rationally. And what any Thames-side duty may require in a particular case will depend on the relevant context and the facts and circumstances of that case. What inquiries are reasonably required in this case? This doesn't raise a general issue that the court needs to resolve of application to other cases. Secondly, the judge's decision in this case, his decision on the absence of any need for further inquiries, was itself fact sensitive. It depended on the difficulty and lack of utility in the type of inquiries that the appellant suggested were rationally required at the hearing before him. The judge deals with this. I can provide you with the references. I'm not sure it's necessary to take them up. But paragraph 76 of his judgment, he accepts the evidence of Dr. Brown as the basis for which the inquiries suggested by the claimant were not required, and he reaffirms that conclusion in paragraph 92 of his judgment. And it may be unnecessary for the court to read the evidence, but I can provide you with the references to what Dr. Brown actually said in her evidence, which the judge relied upon. You'll find Dr. Brown's second witness statement in the supplementary bundle, tab 1, page 53, and the passages of particular relevance that deal with why the inquiries suggested by the claimant were not reasonably required are at paragraphs 5 to 12 and 18. And this was the material that the judge essentially accepted. And they're all detailed reasons based on the nature of the decision being contemplated and particular difficulties that would arise in this case. So I say ground 2 raises no issue no short point of general application which the court should determine which would be of significance in that case.
I mean, the thrust, Dr. Brown's evidence is that it would take years to assemble all the evidence that's required.
There was an error, unreality about the type of inquiries that the claimant was suggesting below. The suggestion was that the Secretary of State was required to conduct some form of empirical assessment of the ecological effects of badger culling on species and habitats that would fall within Section 40 generally. Now, that type of investigation involves an inordinate amount of work, would take a huge amount of time, and would in any event require culling to continue during the period where you were performing the assessments. Otherwise, the very thing that you were seeking to test, it's not a reason for stopping doing that. If you want to perform these inquiries, the very thing that was being challenged would have to continue during the period when the investigation was ongoing. So it was a very clear case for the judge on the basis of the evidence before him, and he rejected it. But for present purposes, I focus on the fact that these are case-specific reasons that were given. It's why the particular inquiries that the claimant had suggested were not reasonably required. It's a fact-sensitive conclusion that the judge arrived.
You presumably say that since the government has indicated that culling will now come to an end, that the precise facts against which the judge came to his view on construction are unlikely to be replicated.
That's correct, my lord. You can only make a decision or indicate a decision to phase out once, as it were. So that indication has been given, and it's subsequently there have been other decisions. So the indication of the ambition to phase out supplementary culling has been given effect in guidance that's given to Natural England in May 2021. So it is on the way out. Supplementary culling is on the way out. And as I say, as my lord puts to me, the precise type of decision that was an issue in this case is unlikely to arise again in the future. Particular type of culling and what's to happen with that type of culling.
It may depend on how long the phasing takes.
Those are my brief submissions on why I say that the appeal is academic and should not be considered. But I emphasise again the point I made at the outset. There isn't a declaration available to the claimant in any event. So the question is simply whether the court would wish to write a judgment dealing with grounds 1 and 2 and commenting on the judge's reasoning. And that is an exercise which, in my submission, the court should not entertain in this case.
Thank you very much. Thank you very much, Mr. Musser. Do you follow Mr. Coates?
I don't. My lady, I won't say much because it's much repetition. Can I just draw a couple of points out? The first one is the pleading point that has appeared at various stages. Can I just refer the court, please, to Lord Justice Bean's order, which granted us permission to apply for judicial review. It's page 196 of the core bundle. And the ground on which we had permission and which we pursued for Mr. Justice Griffiths was the defendant in publishing the Next Steps 2020 document was bound but failed to have regard to the purpose of conserving biodiversity as required by section 41 of the 2006 Act. So that was the issue. However shortly it was pleaded, that was the issue on which Lord Justice Bean had granted permission to apply for judicial review, and that was the issue that was then pursued.
Sorry, can you just show us where it was again on 196?
I'm sorry, it's 196. It says under ground 3A in the reasons. That's the sole ground on which permission to apply for judicial review was granted. So we refused permission twice by the High Court.
Yeah.
And Lord Justice Bean was persuaded that that ground was arguable, and the matter went back to the High Court. The second point, I think I'd just very briefly say, I don't accept that obviously the case...
Before you do, I'm not quite sure why you're drawing our attention to this. It goes to pleading and the basis upon your claim, but remains the same, doesn't it? That Mr. Musser said this was the case that was before the judge below.
Yes, I think Mr. Musser wants to suggest that the Section 40 argument was somehow tangential, but it was the sole issue on which we had permission to apply for judicial review.
I didn't actually take that from his submissions, but if he meant to imply that, it went over my head anyway.
I've dealt with the case of L. I don't say it's a direct parallel, but there are relevant considerations here that apply to this case too, and obviously the ongoing relationship is a different one. My learned friend says the Secretary of State...
Well, this is a response rather than a repeat, so haven't you made these points before?
My lady, I was just going to say my learned friend suggests that the Secretary of State didn't know about the engagement with Natural England, but that's wrong. We know that to be wrong. So I think that was perhaps not an accurate way to put it to the court. The Secretary of State is aware of the ongoing engagement with Natural England. I won't deal with the amendment to Section 40.
Well, again, in fairness to Mr. Musser, because he doesn't get any chance of response, what he said was that he couldn't say because Natural England is not his client. So I think in fairness to Mr. Musser, he didn't say that the Secretary of State wasn't aware. It was just saying that whatever's going on with Natural England in other contexts.
I know the issue arose in litigation where both Mr. Musser and his clients were a party. That was when the ongoing engagement occurred.
I see.
So Mr. Musser wasn't a party, of course, he was a representative. But the point is that the relationship is known, and the ecological information on which the Secretary of State has recently opined is derived from Natural England. And that's the point. Is the Secretary of State relies on Natural England's advice about the ecological implications, and that was what the December 2021 ministerial submission was based upon. In respect of the duty of inquiry and ground 2, I don't accept Mr. Musser's submissions where he says it was an impossible task, and that in a sense is also confirmed by the submission that went to the Secretary of State, because the Secretary of State was expressly invited in December 2021 to consider what should be done in terms of research to have a better understanding of the ecological impacts, and that's page 20 of the further supplementary bundle. In respect of phasing out, and my Lord Justice Haddon-Cave's question, the position is complex. I think the Secretary of State has made various pronouncements about the direction of badger culling, and ultimately the strategy decisions have to be replicated in guidance to Natural England. That's where the Secretary of State gives effect to his policy through giving guidance to Natural England. You should licence on these terms and in these times. The work that's ongoing in respect of vaccination, for instance, which is referred to in next steps, is, as far as the Secretary of State is concerned, ongoing and not yet concluded. So I don't think it can be said with confidence that this is a one-way matters heading in a single direction. I don't think that would be a fair summary of where matters stand on culling. And then finally, I deal with the technical point that my learned friend makes about ground 4. My submissions are these. The question of relief, of course, is at large when you come to an appeal. If the appeal is allowed, the Court of Appeal will decide for itself whether or not to grant relief and on what terms. So I don't accept there's some sort of statute bar on the court considering the question of relief. There has been a clear recognition by the appellant that the relief originally sought, and which the judge said he would not and could not grant, cannot now be pursued. But the canvas has changed such that we say we are entitled to relief, but in a different form. And that's the declaratory relief that we've made clear we now pursue in light of the decision 3 weeks ago to admit the evidence of the Secretary of State. Yes, we accept that the decision to adopt next steps would have been the same, and we know that because the Secretary of State has decided that in December 2021. I would have made the same decision, and I continue to make the same decision. We can't gainsay that. There's no longer an evidential question there. But what we do say is that the court should find that the duty did nonetheless apply. Unless that consists further.
Didn't think so. Thank you very much. Very much. We'll retire to consider this issue.
Court rise.
I shall ask that my Lord Justice Dingemans gives the first judgment on this point.
This is an appeal against the order of Mr. Justice Griffiths, dated the 9th of August 2021, by which the judge dismissed the claim for judicial review brought by the appellant Thomas Langton. Mr. Langton had sought judicial review of the decision of the respondent, the Secretary of State for Environment, Food and Rural Affairs, to publish, or as Mr. Turnier has explained this morning, to adopt in 2020 the policy Next Steps for the Strategy for Achieving Bovine Tuberculosis-Free Status for England, the government's response to the Strategy Review 2018, referred to as the Next Steps policy. The Next Steps policy is a strategy for the next 5 years, setting out various steps to be taken. It permits supplementary badger culling under 2-year licenses. Supplementary badger culling is intended to ensure that the relevant local badger population does not grow back to pre-cull levels. The Next Steps policy aims to go to a phasing out of badger culling. It was published in relation to a paper called the Godfrey Review. The evidence shows that the policy of badger culling, which aims to prevent the spread of bovine tuberculosis and to protect cattle, has provoked strong views on both sides of the debate. Mr. Langton is a well-known campaigner against badger culling. The claim was brought on the basis that the Secretary of State had failed to comply with his statutory duty under Section 40 of the Natural Environment and Rural Communities Act 2006, which I'll refer to as the 2006 Act, which gave effect to various international obligations. Section 40 provides that, inverted commas, the public authority must, in exercising its functions, have regard, so far as is consistent with the proper exercise of those functions, to the purpose of preserving biodiversity, close inverted commas. The judge dismissed the claim below on 2 main bases. The first, that the duty was to have regard to the purpose of conserving biodiversity, so far as is consistent with the proper exercise of the Secretary of State's functions. The judge didn't consider that the Secretary of State had to have regard to biodiversity, given the factual situation showing that this had been considered on many occasions before the publication of the Next Steps policy, and the judge said nothing had changed, getting clearer research results showing that the effect of budget culling on diversity would be very difficult, and the Godfrey Review had not suggested that anything had changed. In any event, Natural England was under a duty itself to consider biodiversity when considering whether to grant licences. It might be noted that these are fact-specific matters in relation to the publication of the Next Steps policy at that time. It is apparent that these conclusions are challenged on behalf of Mr. Langton. Secondly, the judge held that even if the claim had succeeded, he would have dismissed it because it was highly likely that the outcome would not have been different, and applied Section 31, brackets 2A, close brackets, of the Supreme Court Act 1981. Mr. Langton sought permission to appeal. It was refused by the judge below, but he was granted permission to appeal by Lady Justice Simler on 3 grounds. First, that the judge should have found that the Secretary of State had a duty to consider biodiversity under Section 40 of the 2006 Act. Secondly, that the Secretary of State had a duty to make investigations to comply with his duty under Section 40 of the 2006 Act. And thirdly, that the judge was wrong to find that the result would have been the same if the Secretary of State had discharged his duties under the Section 40. After permission to appeal was granted, the Secretary of State sought permission to rely on fresh evidence from Dr. Brown, a senior civil servant, showing that a new decision had been made by the Secretary of State in which Section 40 had been expressly considered, but with the same outcome, namely that the Next Steps policy was not withdrawn. Mr. Langton objected to the admission of this fresh evidence, but Lady Justice Simler made an order admitting the statement of Dr. Brown. Lady Justice Simler also dealt with complaints made on behalf of Mr. Langton about the way in which the Secretary of State had dealt with the disclosure of that further decision. Further, Lady Justice Simler directed the parties to file submissions about whether the appeal had become academic. The parties filed rival submissions. It was common ground that the third ground of appeal, about whether the Secretary of State would have made the same decision, was academic, but it was contended on behalf of Mr. Langton that the appeal about whether Section 40 was engaged and whether there was a duty to investigate was not academic, that the duty had been breached, and that although the original relief was sought was not available, declaratory relief ought to be granted. The question of whether Section 40 of the 2006 applies, it was said, was an enduring one. The Secretary of State contended that the appeal was academic and that there was no reason to hear the appeal. The papers were then referred to me as Supervising Law Justice for Public Law, and I directed that the parties identify a revised list of issues in the light of the admission of the further evidence and a timetable for the hearing. The parties agreed issues in the light of the fresh evidence and produced a timetable for submissions. The revised issues were whether the appellant's appeal had become academic in the light of the Court of Appeal's decision to admit the third witness statement of Dr. Eleanor Brown. Secondly, if so, whether the appellant's appeal on grounds 1 and 2 should nevertheless be heard on the basis that there are exceptional circumstances justifying the hearing of the appeal in the public interest. And thirdly, if the merits were addressed as to ground 1 of the appeal, whether the judge was wrong in concluding that the Secretary of State was not required, pursuant to Section 41 of the 2006 Act, to have regard to the purpose of conserving biodiversity through considering the ecological consequences of continuing culling when publishing those parts of the next steps policy which relate to supplementary badger culling. And fourthly, as to ground 2, whether the appellant's ground 2 provides any basis for challenging the reasoning of the judge in the light of the pleaded case below. And if so, whether Section 41 of the 2006 Act imposed a duty of inquiry on the Secretary of State. If so, whether the judge was wrong to conclude that the Secretary of State had not breached that duty. And the fifth issue was whether the appellant was entitled to any declaratory relief. Mr. Turney, on behalf of Mr. Langton, and Mr. Masser, QC, on behalf of the Secretary of State, have developed their written submissions orally today. And I am very grateful to Mr. Turney and Mr. Fulbrook and Mr. Masser and Mr. Coates for all their helpful written and oral submissions. Statutory provisions. It might be noted that Section 40 of the 2006 Act has now been amended by Section 102 of the Environment Act 2021, but these provisions making the amendments have not yet been brought into force. Relevant law relating to academic claims. As a general rule, where a claim is academic, where there is no longer a case to be decided which will directly affect the rights and obligations of the parties, it will not be appropriate to hear the proceedings or to permit judicial proceedings to be brought unless there is a strong public interest in the matter being heard. See R and the Secretary of State for the Home Department, ex parte Salem, 1999, 1 appeal cases, 450. This approach has recently been reaffirmed by the Court of Appeal in R, L and Devon County Council 2021 EWCA Civ 358, in particular at paragraphs 38 and 64. In that case, the Court of Appeal held that a judge at first instance was wrong not to decide a short point of construction which raised issues of general interest where the parties were ready to argue the point and where the judge granting permission to apply had held that the position was not academic. There was also an ongoing relationship between the parties. Where an academic matter raises issues with potentially wider implications, the Court may also intervene. See R and Heathrow Hub Limited and Secretary of State for Transport 2020 EWCA Civ 213 2020 4 CMLR 17, in particular paragraphs 208 and 216. An example of an academic claim is where the public authority has agreed to reconsider the decision which forms the basis of the challenge. But even then, there are exceptions to this. See R. Karzai and Birmingham County Council 2010 EWHC 2576 Admin. The Court has entertained academic claims where there are a large number of similar cases which exist or are anticipated, or at least some other similar cases, and the decision will inevitably depend on the relevant circumstances. In my judgment, where the original decision has been reconsidered in this case, the challenge brought on behalf of Mr. Langton, which sought the quashing of the decision so that it could be retaken, has become academic, and the appeal from that claim is also academic. there is nothing more that could have been achieved at first instance, because it will not directly affect the rights and obligations of the parties to this claim. This means that it is necessary to consider whether there are exceptional circumstances to justify hearing the academic appeal. In my judgment, there are no exceptional circumstances, which mean that this court ought to consider the academic challenge in this appeal, and there are good reasons not to entertain this appeal. First, the main point on the appeal is a question of statutory construction, which is critically dependent on the circumstances, as Mr. Macur has pointed out in his submissions this morning. The judge found that Section 40 did not apply because it would not have been, open inverted commas, consistent with the proper exercise of those functions, close inverted commas. This inevitably involves a specific consideration about what was the proper exercise of the functions in this case. Secondly, it appears from the information available to the parties and to this court that there are no other cases which raise the same point about the interpretation of Section 40 of the 2006 Act. Thirdly, the statute, Section 40 of the 2006 Act, has been amended in material respects. It is only fair to note that the amendment has not yet been brought into force, and Mr. Turney noted in his submissions that there was no information about when this might be brought into force. It is also right to note that material parts of the statutory wording, consistent with the proper exercise of those functions, remains in the amended statute. But in my judgment, this does not undermine the fact that the wording has changed and that the application of the material part of the statutory wording which continues is fact-specific. Fourthly, the point about the duty to make inquiries under Section 40 wasn't expressly pleaded below, although it was raised in oral argument and was covered by the grant of permission to apply for judicial review by Lord Justice Bean. But in the judgment below, the judge dealt with this by reference to the specific facts of the case. In my judgment, a court should be reluctant to hear an academic point on an appeal which was not pleaded, but which was then determined below on the specific facts. Finally, I accept that the parties are here before this court, which can be a material consideration in favour of hearing an otherwise academic appeal. But they are here to argue whether the appeal is academic, as they have done, and if we decide that it is not academic or that it should be heard, then to argue the merits of the appeal. But this doesn't justify engaging in this particular academic appeal. For the reasons set out above, I would dismiss this appeal because it is academic and because there are no exceptional circumstances justifying the court hearing it.
I agree.
I also agree. Mr. Macur.
Lady, I'm grateful. The court wishes to deal with consequential matters now.
We do.
We seek our costs. Of
Your schedule.
There isn't a schedule, I'm afraid, my lady. That's for two reasons. One is that our costs are capped at £5,000 under the Aarhus Convention. And secondly, the solicitor who has custody of the case is absent on leave at present and won't be available until next Monday. If the court would like a schedule, I only claim up to the limit of £5,000. If the court would like a schedule, we can file it subsequently with the court next week.
I think in your skeleton argument you said that the Court of Appeal had not imposed...
The court hasn't made an order yet under the Aarhus Convention capping costs at £5,000.
It's normally done when permission to appeal is granted.
Yeah, indeed, my lord. I think it just wasn't dealt with in the order that Lady Justice Simler gave. We didn't ourselves, to be fair, raise reasons why the Aarhus Convention
So it's common ground that your costs are limited to £5,000?
Indeed, my lord. And so we only claim up to that sum.
And can I just ask this, because I know there's been some jurisprudence on it. If, for example, a court makes an order that you get 80% of your costs at first instance, does that mean, and your costs would have been 100,000, but you're capped at 5,000, does that mean you only get 80% of the 5,000?
No, my lord. It's an objective cap in terms of the amount that's recoverable.
Yes, I knew that was still an issue, but I didn't know how it had been resolved. Thank you.
So you haven't got a schedule, but have you been given any instructions as to likely ballpark figures of costs?
The only I can seek further instructions, but they're going to exceed £5,000 very significantly.
Yes, but it's just to give us an idea, given that, well, if you say very significantly, I suppose whatever we may want to do in relation to the late disclosure of the Brown 3.
Indeed, my lady. My lady, I'm told the costs are in excess of £50,000.
Nice.
So it's 10% of
Yes, I
what we
understand.
have incurred.
Yeah.
Can I just ask you something on costs, if that's all right? If I know the point about duty of candour was addressed by Lady Justice Simler, and that's all been dealt with. But if the Secretary of State had disclosed to the single Lord Justice considering this on the papers that in any event the decision's been made and it's the same again, it seems very unlikely that permission to appeal would have been granted. Now, of course, you can play your cards as you see fit, but it might be thought that you'd slightly invited the grant of permission, and what has happened?
My Lord, 2 points in respect of that. The first is that Lady Justice Simler was obviously dealing in granting permission to apply for judicial review with the reasoning of the judge below and whether it disclosed arguable errors with real prospect of success or whether there was some other substantial reason for granting permission. And that assessment was directed at the judgment below. There are cases in the bundles where the court has been informed that an appeal is academic at the permission stage, has nevertheless granted permission, but decided the question of whether the appeal is academic at a hearing. The Rehum, which is actually a decision of Lady Justice Simler, which is in the bundles, is one such case. So the factual situation here, whilst I accept is unusual, it's not unprecedented, it happens. But more substantively, second point is, immediately on applying to adduce the evidence and seeking permission to adduce Brown 3, we invited the claimant to withdraw the appeal on condition that there's no order as to costs. And we've repeated that offer when Lady Justice Simler made her order saying that the evidence would go in. So what we have sought to do is mitigate the effects of Brown 3 being adduced at the time we put in our respondent's notice. We've been put to the cost of appearing and arguing the appeal, and we've had to obviously prepare on the basis that it may be that the court would wish to address the substance as well as the question of whether it's academic. And in those circumstances, given that we did seek a way out and seek to mitigate the effects, and that we accept that we're only entitled to a limit of £5,000, I say that the proper order is an order awarding us £5,000 in costs. Now, if you're against me on that, then I say that the alternative, as a fallback position, the alternative is no order as to costs is the outcome that the court should prefer. Those are my brief submissions on costs. As I say, if it would assist the court to have a schedule, we can arrange for it to be prepared. But we would ask for 7 days because, as I say, the solicitor who has conduct of the matter is currently unavailable and won't be present again until next week.
All right, thank you.
Lady, we say that the appropriate order is no order as to costs. It's an unhappy sequence of events, and it could have been dealt with differently, and in my submission plainly should have been dealt with differently by the Secretary of State. One can perfectly see, as my Lord Justice Dingemans said, the Secretary of State wished to keep his cards close to his chest, and that is of course because he considered Section 40 duty, and that would be regarded perhaps by some as a concession that he should have done so. Otherwise, he was considering something which was legally irrelevant when he received the briefing in December 2021. That point should have been expressed to the court, first of all, and to the claimant, and it wasn't. And it's very regrettable that we got to that position in April. By that time, the court had decided that this hearing should be expedited, should be heard this term, because of the significant delay in this case coming forward and the ongoing badger culling. So by that time it had already been established that the hearing would come on in July. The decision to admit the evidence, I say quite properly, my client was entitled to resist the admission of that evidence. It's a novel point. There aren't any cases on the admission of that kind of evidence at this stage that have expressly dealt with it. Ladd-Marshall principles are strict, and the circumstances have to be exceptional to admit the evidence, and we were entitled to resist it. And it was then on the 4th of July that that evidence was admitted and that the complexion of the case actually changed. I say in those circumstances, 2 points. One of them is that my clients have obviously incurred significant cost in dealing with the late evidence. So we've had to address that evidence, we've had to address the submissions that's been made, we've had to make further submissions to the court, so we've been put to significant cost in that regard. Secondly, in all those circumstances, it was reasonable for this hearing to be occasioned, and indeed that was the direction of my lord, that it should come to court. We made short written submissions. If the court took the view that the matter could be disposed of on paper, no doubt the court would have done so. So I say we were properly here to argue out that point. And in those circumstances, the conduct of the Secretary of State means that my client's been put to significant extra cost in the course of this appeal. That's cost which obviously is irrecoverable, but my client shouldn't be be put to the further cost of making that contribution towards the Secretary of State's own costs of proceeding with the appeal in this way. The final point I make is that there's obviously recognition, I can't go into the merits now, but there's recognition by Lady Justice Simler of the arguability of the points and the importance of the points to be determined when permission was granted. And I say, in fact, there was a good prospect that the appeal would have succeeded, but for those circumstances. So in those circumstances, it was reasonable for my client to take the point that the claim should be heard, because the prospects of its success, if the court was willing to hear it, were, in my submission, strong. So in all those circumstances, I say no order as to costs is the appropriate relief. I've already dealt with the counter-offer that we made to the Secretary of State, but of course we did reject the proposition that the appeal should be dismissed at that stage, but it was reasonable to do so in my submission.
All right, thank you. We'll retire.
Rise.
we now address the issue of the costs of the appeal. The Secretary of State asks for the costs of the appeal limited to the Aarhus cap of £5,000. That is resisted on behalf of Mr. Langton, who submits that there ought to be no order as to costs. The basis for the resistance is that the Secretary of State has, as I've already indicated in the brief reasons that I gave this morning, dismissing the appeal, adduced late evidence in the form of a witness statement from Dr. Brown, which related to matters which had occurred before the grant of appeal. That didn't involve any breach of the duty of candour for the reasons that were given by Lady Justice Simler when she directed that the material ought to have been admitted. But on the other hand, it effectively meant that Lady Justice Simler made a decision in the dark about what had happened since the date, and meant that permission to appeal was granted when, in my judgment, it would not have been if Lady Justice Simler had known all those matters. And I say that and make that finding because Lady Justice Simler admitted the evidence when she knew about it, and then immediately directed the parties to make submissions about whether the appeal was academic. For all those reasons, in my judgment, it is appropriate not to award any costs to the Secretary of State until the date of Lady Justice Simler's order admitting the fresh evidence. But from that date, although Mr. Turney is right to point out that it was perfectly reasonable to continue to oppose the Secretary of State's proposals for dealing with the matter, and the Secretary of State had offered that the appeal be dismissed with no order as to cost. They lost, and in those circumstances, the usual consequences of losing should apply. For all those reasons, in my judgment, the appropriate order for costs would be the Secretary of State's, there'd be no order as to cost to the appeal until the date of Lady Justice Simler's order. After that date, the Secretary of State should have the costs of the appeal to be capped at £5,000. The Secretary of State is to provide a Form N44 signed by the solicitor within 7 days, and if there is any dispute about whether the Secretary of State has got to the cap, that can be resolved by written submissions, 2 pages each, directed to me. I very much hope not to see this case again.
It's N260, Practice Direction 44. So the application for costs is determined, as you've heard. The N260, as your client will know, Mr. Musser, must be signed by the solicitor who certifies the costs in the sum. And you've heard my orders to the order made by the court that they are only the costs that arise following the offer made to dispense with the appeal on the basis of no order for costs after the order of Lady Justice Simler admitting Brown 3, capped at 5,000. If you don't get to 5,000, which is something we're not speculating about, obviously it's only up to the amount.
I understand, my lady. As I've understood the order, it's from the 4th of July onwards, which is when Lady Justice Simler made her order. You'd like the schedule to be confined to costs incurred after that date, so as to be able to assess whether the £5,000 cap has been met or not. We will, of course, try and reach a resolution in the first instance and seek to avoid troubling the court, if at all possible.
Thank you very much. May we again thank all counsel for their submissions and their focus during the course of this morning's hearing, and also, of course, for the written submissions that we've had regard to as we looked in the core appeal bundle, just in case we did need to go further than a preliminary view. So thank you all very much.